session. We are into the third session dealing with judicious approach by family court judges to maintenance. This is another area which is of importance in family court matters. We have this afternoon with us Honourable Mr. Justice Vivek Puri. He brings in a rich experience. Came to the judicial service in the year 1991. Superior Judicial Service 2001. District and Session Judge 2012. And was elevated in November 2021. What rich experience. We are going to be benefited. In fact, this is a unique couple. Both Justice Vivek Puri and Justice Archana Puri, if I take the liberty in this context. They both came to the judicial service in the year 1991 and were elevated together in November 1991. That's the beauty of happy couple as such, because the purpose of or the challenge of the family courts is to build up happy homes, happy families, and happy children. And therefore, we have a living example with us in this context. Our resource person for this particular session is Mr. Hemraj Mittal. With a good academic background, he has been Additional District and Session Judge since the year 2019 and is presently the Principal Judge, Family Court, Fatehabad. With his experience, this particular domain of maintenance is something significant which he would be sharing with the family court judges so that whatever issues which are there in this particular context are taken care. May I request Mr. Hemraj Mittal to start the session, and then we would, after he finishes, would have the concluding remarks from Justice Vivek Puri. Over to Mr. Hemraj Mittal.
I wish a very warm good afternoon to Honourable Mr. Justice Vivek Puri, Judge, Punjab and Haryana High Court, Chandigarh, Shri Balram Gupta, Learned Director, Academics, Chandigarh Judicial Academy, and all my fellow judicial officers from state of Haryana and Punjab who have joined in this online session. We are really grateful, and it is my proud privilege to express gratitude on the behalf of all the judicial officers to His Lordship, Honourable Mr. Justice Vivek Puri, who has taken out time from his busy schedule to guide us on one of the most important issues facing a family court judge daily in and out, that is maintenance. Before starting with the main topic, I'd like to give a brief introduction regarding maintenance. the Hindu law, even 1,000 years back, thought of providing maintenance to destitute wife and children. The old Hindu law vested the right of maintenance under diverse circumstances on a large number of persons, especially women, more than any other old legal system did. So strong was the obligation on a Hindu to provide maintenance to the relatives that Manu, the first lawgiver in Hindu law, said aged mother and father, chaste wife and infant child must be maintained even by doing 100 misdeeds. Thus, the oft-repeated concept that a husband may beg, borrow or steal, but he has to maintain his wife and children and parents is borrowed from Manu, the first lawgiver in Hindu law. As per Manu, it is the pious duty of a Hindu which he owed to his dependent relations and by which both his person as well as property were bound. Hindu law made a distinction between legal and moral obligation to pay maintenance. When it was a legal obligation, it was binding even if the person did not have any property. But when it was a moral and optional obligation, then it was a matter of conscience and was unenforceable. Even from the present day concept, the Manu has given a large number of category of persons who were entitled to maintenance. Manu is cited by Shri Krishna's commentary on Daya Bhagga as saying, the father, the mother, the guru, elderly relations worthy of respect, a wife and offspring, poor dependent, a guest and religious mendicant are the persons who are entitled to be maintained. Thus, the list is even a large one as compared to modern law. The object of the maintenance proceedings is not to punish a person for his past neglect, as held by Honourable Supreme Court in Chaturbhuj versus Sitabai in 2008. Maintenance laws have been enacted as a measure of social justice to provide recourse to dependent wives and children for their financial support and to prevent them from falling into destitution and vagrancy, as held by Honourable Supreme Court in Rajneesh versus Neha 2021, Volume 2, SEC, page 324 in para 9. This judgment of the Honourable Supreme Court in Rajneesh versus Neha has cleared most of the issues pertaining to maintenance and is now the foundation of law of maintenance in this country. Section 125 CRPC gives effect to natural and fundamental duty of a man to maintain his wife, children and parents so long they are unable to maintain themselves. It provides a speedy remedy for supply of food, clothing and shelter to deserted wife and children as held in Savita Bhan Somabhai Bhatia versus State of Gujarat by the Honourable Supreme Court. The role of the court in maintenance cases is very important. The Honourable Supreme Court has held that role of the court is not that of a silent spectator or of a passive agency. When a dispute is brought before the court where maintenance of a neglected wife or a minor child is in issue, the court must take genuine interest to find out the truth of the matter. Thus, the court has to play a positive role and not merely a passive role as in some other kind of litigation. It is also the duty of the lawyer appearing from the applicant to play his role properly at the right time. This has been so held by Honourable Supreme Court in Sumitra Devi versus Bhikan Chaudhary in 1985 Supreme Court. Regarding the interpretation of provisions regarding maintenance, it has been held by Honourable Supreme Court that those are to be liberally construed in favor of the destitute women, children and parents. The provisions under Section 125 are not to be utilized for defeating the rights conferred by the legislature to the destitute women, children or parents who are victims of social environment, as held by Honourable Supreme Court in Dwarika Prasad Satpathy versus Vidyut Pravya Dikshit in the year 1999. In Ramesh Chandra Kaushal versus Mrs. Veena Kaushal, Honorable Justice Krishna Iyer has held that where there is two interpretations are possible in case of maintenance, then the alternative which advances the cause of the derelict has to be adopted. It is pertinent to mention here that this judgment has been also quoted in the latest case of Rajneesh versus Neha in the year 2021. Next, we come to the jurisdiction of the family courts insofar as cases of maintenance are concerned. The jurisdiction of the family court under various statutory provisions can be divided in two categories. One is secular provisions, which are applicable irrespective of the religion of the parties concerned. And secondly is under the personal laws applicable to various communities, which is applicable separately depending upon the community to which the parties belong. Under Section 7 of the Family Courts Act 1984, the family courts have jurisdiction to deal in respect of all suits and proceedings for maintenance, accessible by all district courts as well as all subordinate civil courts under any law for the time being in force. The jurisdiction accessible by a magistrate of first class under Chapter 9 relating to maintenance for wife, children and parents has also been conferred on the family courts. Moreover, such other jurisdiction as may be conferred on it by any other enactment can also be exercised by the family court. Here there is an important distinction. So far as civil cases are concerned, all jurisdiction of the district as well as subordinate civil courts have been conferred. But insofar as the jurisdiction in criminal matters of a magistrate is concerned, only jurisdiction under Chapter 9 has been conferred on the family courts. Thus, there are certain other provisions also where magistrate can grant maintenance, but those have not been conferred on a family court, as we will discuss a little while later. As a necessary corollary of Section 8, the jurisdiction of all other courts have been specifically excluded where a family court has been constituted. Similarly, all the pending cases which are pending before other courts would be transferred to the family courts where they are constituted. As I have already said, that jurisdiction of the family court to grant maintenance is under two categories. One is secular provisions, applicable irrespective of religion. In this Section 125 CRPC, maintenance pendent allied under Section 36 of the Special Marriage Act and maintenance at the time of passing of the decree or any time thereafter under Section 37 of the Special Marriage Act are covered. Moreover, the family courts also have jurisdiction under personal laws applicable to various communities, and it will depend upon the community to which a person will belong in the exercise of this jurisdiction. The most important provisions covered under this category are maintenance pendent allied under Section 24 of Hindu Marriage Act, maintenance at the time of passing final decree, also called permanent alimony, under Section 25 of the Hindu Marriage Act, maintenance under Hindu Adoption and Maintenance Act 1956, maintenance and permanent alimony under Section 37 of Indian Divorce Act 1869, which is a personal law governing the Christians. Similarly, maintenance and permanent alimony under Section 9 and 30, Section 39 and 40 of Parsi Marriage and Divorce Act 1936, which is a personal law governing the Parsis. Maintenance under personal law of the Muslims also fall in this category. The family courts do not have any jurisdiction to grant maintenance under Protection of Women from Domestic Violence Act 2005. Since the Family Courts Act was constituted prior to the coming in force of the Domestic Violence Act in the year 2005, no such provision was made in the Family Courts Act. But there is no such provision in the Domestic Violence Act also. Thus, the Family Court cannot entertain an application under Section 12 of the Domestic Violence Act. However, indirectly under Section 26 of the Domestic Violence Act, power has been granted to the family courts to grant relief under Section 18 to 22 of the said Act, provided some other proceeding is pending between the parties before the family court in any such proceedings. This is very important that even if we have a case under Section 125 CRPC or under the Hindu Marriage Act, as per the provisions of Section 26 of the Domestic Violence Act, we can also, in addition to the relief under the provisions of the applicable Section 125 CRPC or Hindu Marriage Act, can grant relief under Section 18 to 22 of Domestic Violence Act also. But if a person institutes a separate petition under Section 12 of the Domestic Violence Act, the same is not maintainable. The relevant law in this regard has been laid by the Honourable Supreme Court in Abdul Majid Khan Patni versus Atif Iqbal Missouri 2014 Supreme Court. There are certain other provisions also where the family courts do not have jurisdiction to grant maintenance, and only the concerned authority or magistrate or court which has been granted jurisdiction can grant maintenance. For instance, under Muslim Women Protection of Right on Marriage Act 2019, which deals with banning of triple talaq, the family court do not have jurisdiction to grant maintenance, which is called subsistence allowance under Section 5 of the said Act, and only magistrates are entitled to grant maintenance to divorced Muslim wife and her dependent children covered under the provisions of the said Act. Similarly, in Maintenance and Welfare of Parents and Senior Citizens Act 2007, the family courts do not have any jurisdiction to grant maintenance. Section 4 of the aforesaid Act provides for maintenance tribunals which alone are entitled to grant maintenance to parents and senior citizens covered under the provisions of the said Act. Now we come to the territorial jurisdiction in maintenance cases. In so far as Section 125 CRPC is concerned, under Section 126 CRPC, proceedings under Section 125 CRPC may be taken up against any person in any district where the respondent is, or where the respondent resides, or the petitioner wife resides, or they last resided together. Thus, a very wide jurisdiction has been granted. The expression reside implies something more than a brief visit, but not such continuity so as to amount to domicile. The remedy is a summary one, and the person seeking remedy is ordinarily a helpless citizen. So the words should be liberally construed without doing any violence to the language, as held by Honourable Supreme Court in Jagir Kaur versus Jaswant Singh. The jurisdiction under Hindu Marriage Act would be governed by the provision applicable to the main petition, that is Section 19 of the Hindu Marriage Act 1955, which again confers a very wide jurisdiction in this regard. The provision under Special Marriage Act 1954 again would be governed by the jurisdiction in the main petition, which is Section 31 of the Special Marriage Act 1954, which is exactly paramateria to the Section 19 of Hindu Marriage Act 1955. In all these cases, a very wide jurisdiction has been conferred, and petition can be filed where the marriage was solemnized, the respondent at the time of presentation of the petition resides, the parties to the marriage last resided together, where the wife, if she is a petitioner, is residing on the date of presentation of petition. It is important to note that whereas the husband has not been granted this right, that he can file a petition where he is residing on the date of presentation of the petition, but such a right has been conferred on the wife. If she is a petitioner, she can file. So far as territorial jurisdiction under Hindu Adoption and Maintenance Act 1956 is concerned, there is no specific provision regarding territorial jurisdiction, in Hindu Adoption and Maintenance Act 1956. In absence of a specific provision in the Act itself, the question of jurisdiction of civil court, where the plaintiff is required to institute proceedings for maintenance, can be determined only with reference to Code of Civil Procedure. The maintenance proceedings in such cases can be initiated under Section 20 of Code of Civil Procedure, where the defendant resides or carries on business or personally works for gain, and where the cause of action wholly or partly arises. The same has been held by Honourable Andhra Pradesh High Court in U. Shri versus U. Shri Nivas, 2005. Next important issue is issue of overlapping jurisdiction. Same person can claim maintenance under different enactments. Thus, a Hindu wife can claim maintenance under Section 125 CRPC, also under Domestic Violence Act also, and under Section 24 and 25 of Hindu Marriage Act also. Invariably, we find that applicant or petitioner has filed or availed all or more than two or more than two remedies at the same time. In this regard, so far as Section 125 and Section 18 of Hindu Adoption and Maintenance Act is concerned, the Honourable Supreme Court in Nanak Chand versus Chandra Kishore Agarwal has held that there is no inconsistency between CRPC and Hindu Adoption and Maintenance Act. Section 4B of Hindu Adoption and Maintenance Act would not repeal or affect the provisions of CRPC. Both can stand together. The scope of two laws is different. Section 125 provides a summary remedy and is applicable to all persons belonging to all religions and has no relation with the personal law of the parties. An order passed under Section 125 CRPC by way of compromise or otherwise cannot foreclose the remedy available to the wife under Section 18, subclause 2 of Hindu Adoption and Maintenance Act, as held by the Honourable Supreme Court in Nagarendrappa Natikar versus Nilama, 2013, Supreme Court, page 1541. So far as the issue of maintenance under Section 125 CRPC and under Section 24 of the Hindu Marriage Act 1955 is concerned, it has been held by the Honourable Supreme Court in Sudeep Chaudhary versus Radha Chaudhary that despite of award of maintenance under Section 125 CRPC, the wife is competent to maintain the proceedings under Section 24 of the Hindu Marriage Act 1954 also. However, the amount awarded under Section 125 of CRPC for maintenance is adjustable against the amount awarded in the matrimonial proceedings and is not to be given over and above the same. I will like to mention here that the same is the position in view of the latest judgment in Rajneesh versus Neha, which I have already cited, which lays almost covers all the field in this regard. So far as maintenance under Section 125 CRPC and grant of monetary relief under Section 20 of the Domestic Violence Act is concerned, the Honourable Supreme Court has held that mere passing of an order under Section 125 CRPC did not preclude a person from seeking appropriate relief under the Protection of Women from Domestic Violence Act 2005 in a very latest judgment in the year 2019 in Shom Nakhin Danani versus Tanya Banon Dinani. It arose from a case from Delhi High Court and has been the judgment of the Honourable Delhi High Court has been upheld by the Honourable Supreme Court, in which it was held that Section 20 subclause 1 subclause D of the Domestic Violence Act clearly provides that in proceedings under Domestic Violence Act, the magistrate may direct the respondent to pay maintenance to the aggrieved person as well as her children, if any, including an order under or in addition to an order of maintenance under Section 125 CRPC or any other law for the time being in force, which clearly shows that an order under Section 20 of Domestic Violence Act is not restricted by an order under Section 125 CRPC. So far as issue is whether dismissal of a petition under Section 12 of the Domestic Violence Act debars the proceedings under Section 125 CRPC. Our Honourable High Court in Satpal versus Sheila in the year 2016 has held that mere dismissal of an application under Section 12 of the Domestic Violence Act does not debar the proceedings under Section 125 CRPC, as Section 26 subclause 2 of the Domestic Violence Act provides that any relief available under the provisions of the said act may be sought for by any aggrieved person in addition to or along with any other relief that the aggrieved person may seek in any legal proceedings before civil or criminal court. Dismissal of the application under Section 20 of the Act will not in any manner prejudice the right of the wife to seek relief under Section 125 CRPC. Similarly, it has been held by our Honourable High Court in Punjab Pankaj Kumar versus Reena, Criminal Revision number 53 of 2015, decided in the year 2018, that only because the respondent has been acquitted under Section 498A IPC is no ground to deny maintenance to the legally wedded wife and the child. In Rakesh Malhotra versus Krishna Malhotra, however, an exception has been called for. It has been held that once permanent alimony is granted under Section 25 of Hindu Marriage Act 1955, then instead of application under Section 125 CRPC, the proper application is under Section 25 subclause 2 of the Hindu Marriage Act only. So this calls exception to the general rule. Up till now, we have seen that under different provisions, application can be filed. But once a permanent alimony has been granted under Section 25, then the applicant is not entitled to file an application under Section 125 CRPC, but she can only go under Section 25 subclause 2 of the Hindu Marriage Act for enhancement of the permanent alimony or monthly maintenance already granted under Section 25. The Honourable Supreme Court has held in this regard, and I quote, that one can understand the situation where, considering the exigencies of the situation and urgency in the matter, a wife initially prefers an application under Section 125 of the Code to secure maintenance in order to sustain herself. In such matters, the wife would certainly be entitled to have a full-fledged adjudication in the form of any challenge raised before a competent court, either under the Act or under similar enactments. But the reverse cannot be the norm. So a wife who has claimed maintenance under Section 125 can of course go under Section 25 for permanent alimony. But once the wife has obtained permanent alimony under Section 25, then she cannot file a petition under Section 125 CRPC for maintenance. The only recourse open to her is to go in the said case only for enhancement of the maintenance. Now, a very important issue has arisen before the Calcutta High Court regarding maintenance under Section 125 CRPC after divorce by mutual consent under Section 13B of the Hindu Marriage Act 1955 has been granted and payment of lump sum alimony has been made. In the very latest case of Prasajit Mukherjee versus State of Bengal, West Bengal, Criminal Revision number 1256 of 2017 decided on 2nd of September 2021, the single bench of Calcutta High Court has referred to the larger bench this issue as to whether the wife can still file a petition under Section 125 CRPC for maintenance after her marriage has been dissolved by mutual consent and she has also received a permanent alimony. And under different circumstances, the Honourable High Court has framed reference and given 3 circumstances where whether the wife can claim alimony, after claiming alimony can claim maintenance. The first is where a fresh case, entirely a fresh case under Section 125 CRPC is filed. The second is case under Section 125 CRPC is pending, but the civil court has dissolved the marriage by decree of divorce, and there was no information before the civil court regarding pendency of the proceeding under Section 125 CRPC. The third case is where the under Section 125 CRPC and under section and proceedings under Section 13B of the Hindu Marriage Act, which has already been decided, are in different subdivisions or different districts or different states. The latest position as per the law laid down by Honourable Supreme Court in Rajneesh versus Neha, now we will discuss. It has been held by the Honourable Supreme Court in the latest case that it is inequitable to direct the husband to pay maintenance under each of the proceedings, independent of the relief granted in the previous proceedings. Thus, in a second proceeding, independent of the relief which was earlier granted, maintenance cannot be awarded. The Honourable Supreme Court has laid the following directions to overcome the issue of overlapping jurisdiction and avoiding conflicting orders in para 131 to all the family courts, district courts and magistrate courts throughout the country. The first is where successive claims for maintenance are made by a party under different statutes, the court would consider an adjustment or set off of the amount awarded in the previous proceedings, while determining whether any further amount is to be awarded in the subsequent proceeding. Secondly, it is mandatory for the applicant to disclose the previous proceedings and orders passed therein in the subsequent proceedings. Thirdly, if the order passed in the previous proceeding requires any modification or verification, it is required to be done in the same proceedings only. Thus, any modification of the previous order cannot be made in a subsequent proceeding, as per the Honourable Supreme Court. Next, we come to issue of filing of affidavits of disclosure of assets and liabilities, as per the judgment of the Honourable Supreme Court in Rajneesh versus Neha. In view of the judgment of the Honourable Supreme Court in Rajneesh versus Neha, both the parties are mandatorily required to file affidavits of disclosure of assets and liabilities as per the pro forma given in the said judgment. The aforesaid affidavits are required to be taken into consideration by the court while deciding maintenance, both at interim and final stage. The Honourable Supreme Court has provided three kinds of performers. The first performer deals with affidavit regarding non-agrarian deponents. That is, a person who does not have agricultural land, who lives in a city and has no connection with agriculture. Second affidavit deals with agrarian dependents, Crpc, that is a person who is having agricultural land and lives in a village. The third kind of affidavit is for state of Meghalaya, which is not relevant for our purpose. Thus, depending upon whether the parties are involved in agriculture or not, affidavit as per enclosure 1 and 2 are required to be filed. Before the said judgment, even our Honourable High Court in Jaspreet Singh versus Gurleen Kaur in the year 2020 and Honourable Delhi High Court even earlier has prescribed similar affidavits. But now, since the judgment of the Honourable Supreme Court has come, it will prevail and the performer is to be as per the judgment of the Honourable Supreme Court. The affidavits regarding disclosure of assets and liabilities are mandatory as per the Honourable Supreme Court judgment, as discussed earlier also, but the same can be exempted only under three categories of persons. Firstly, casual laborers or persons belonging to economically weaker sections of society or those living below poverty line. Only in the aforesaid condition, the affidavit can be dispensed with as per para 81, clause I of the judgment of the Honourable Supreme Court. Probably in these cases, the affidavit has been exempted because since that person does not have any property, so it would be useless to call for an affidavit. But only in these cases, affidavit can be exempted. Otherwise, it is mandatory for each party and the court has to enforce filing of the affidavit in each and every case, whether it is a pending case, which is already pending on the date of coming of the in force of the judgment, or a case filed subsequently. In all cases, whether it is under Section 125 CRPC, Hindu Marriage Act, Hindu Adoption and Maintenance Act, wherever maintenance has to be determined, the parties are required to file affidavits regarding disclosure of assets and liabilities. Then certain guidelines have been given by the Honourable Supreme Court, which we will be giving a write-up. So I am not going in detail because of paucity of time. Now is the question of consequences of non-filing of affidavit of disclosure of assets and liabilities. The Honourable Supreme Court in this regard has held that the respondent must submit the reply along with the affidavit of disclosure within a maximum period of 4 weeks. The court may not grant more than 2 opportunities for submission of the affidavit to the respondent. If the respondent delays in the filing of reply with the affidavit and seeks more than 2 adjournments for this purpose, the court may consider exercising the power to strike off the defense of the respondent if the conduct is found to be willful and contemptuous in delaying the proceedings. On failure to file affidavit within the prescribed time, the family court may proceed to decide the application for maintenance on the basis of affidavit already filed by the applicant and the pleadings on record. The next question we deal with is whether a divorced wife is entitled to maintenance under Hindu Adoption and Maintenance Act 1956, because a query was also raised by a London judicial officer in this regard. So the law in this regard is now well settled that though divorced wife is not entitled to maintenance under Section 18 of the Hindu Adoption and Maintenance Act. Section 18 of the Hindu Adoption and Maintenance Act provides that a Hindu wife shall be entitled to be maintained by her husband during her lifetime. Once the divorce has been granted, petition under Section 18 could not be maintained. We are confusing this concept with the concept of divorced wife getting a maintenance under Section 125 CRPC. But under Section 125 CRPC, the legislature, by a deeming fiction, has included a divorced wife in the category of wife. Therefore, she is also entitled to maintenance, even though she is not a legally wife and she has already been divorced and the matrimonial relation has come to an end. But there is no similar provision in Section 18. So a divorced wife cannot claim maintenance under Section 18. The relevant judgment on the issue is Manisha Sandeep Gade versus Sandeep Vinayak Gade, AR 2005, Bombay, page 180. Further, in Pandit Rao Chimanji Klure versus Gayabai 2002, again a Bombay High Court judgment, it has been held that the distinction between maintenance under Hindu Marriage Act and Hindu Adoption and Maintenance Act is that right under Section 18 of the Hindu Adoption and Maintenance Act is available during the subsistence of the marriage only, without any matrimonial proceedings pending between the parties. Once there is a divorce, the wife has to seek relief under Section 25 of the Hindu Marriage Act. It is pertinent to mention here that the aforementioned judgment has also been cited in the latest case of Rajneesh versus Neha by the Honourable Supreme Court in para 29. So now there is no dispute regarding this issue. Now we come to the execution of maintenance orders. Even the Honourable Supreme Court in para 122 in Rajneesh versus Neha has noticed that enforcement of order of maintenance is one of the most challenging issues which is encountered by the applicants. If maintenance is not paid in a timely manner, it defeats the very purpose and object of the social welfare legislation. Execution petitions usually remain pending for months, if not years, which completely nullifies the object of the law. So the execution is one of the most difficult fields in general cases also, but for maintenance cases, it is all the more difficult. Section 18 of the Family Courts Act 1984 deals with execution of decree and orders of the family court. It provides that the orders and decrees other than under Section 125 CRPC of Family Court can be executed as a decree or order of civil court as a provision of CPC. Secondly, the order of the family court under section 125 CRPC can be executed in the manner prescribed under CRPC. Thus, for civil decrees, provisions of the Code of Civil Procedure will be applicable, and for section 125 CRPC, provisions of Code of Criminal Procedure would be applicable. The first method of recovery of maintenance is recovery as fine under section 125 subclause 3 CRPC. Section 125 subclause 3 CRPC provides that if a party against whom the order of maintenance is passed fails to comply with the order of maintenance, the same shall be recovered in the manner as provided for fines. As per section 421 CRPC, when an offender has been sentenced to pay a fine, the court passing the sentence may take action for recovery of fine in two ways, namely recovery as areas of land revenue, and secondly, attachment and sale of movable property. In all such cases, the court may issue a warrant to the collector of the district authorizing him to realize the amount as areas of land revenue from movable and immovable property or both of the defaulter. The second manner of recovery is by issuing a warrant for levy of the amount by sale and attachment and sale of the movable property belonging to the offender. In the latest case of Asha Devi versus Muneshwar Singh 2021, Delhi, it has been held by the Honourable Delhi High Court that property even outside the jurisdiction of the court can be attached and sold under section 125 subclause 3 CRPC. It has been held by the Honourable Delhi High Court that court gives ample prerogative with respect to the jurisdiction where the person seeking maintenance may file for the same and its subsequent execution. The material fact hence would be the presence of the person at the preferred jurisdiction at the time of application for maintenance. Section 125 subclause 3 CRPC empowers the magistrate to issue a warrant for levying the amount due in the manner provided for levying fines and where there is a default in payment in contravention of the orders of maintenance by the magistrate. The same is guided by provisions of section 421 and 422 CRPC, which authorizes the concerned court to sell and attach the property even outside its jurisdiction. So there is no need to transfer a maintenance execution application. Even if the property is situated outside the jurisdiction of the court, still it can be attached. It has been held in the case of Wali versus Muneshwar that even the award of a lok adalat for maintenance can also be enforced under section 125 subclause 3 CRPC. The normal rule is that award of lok adalat is to be enforced as a decree of the civil court. But in case of 125 CRPC, the courts have interpreted the provision to include even application of section 125 subclause 3 CRPC in such cases. The property covered under section 125(3) CRPC is not only tangible property, but even intangible property and debts are also covered. The second method of recovery of maintenance is by imprisonment under section 125 subclause 3 CRPC. The section 125 subclause 3 CRPC provides that if a party against whom the order of maintenance is passed fails to comply with the order of maintenance, the court may award sentence of imprisonment for a term which may extend to 1 month or until payment, whichever is earlier. This is a very important issue, and certain queries have also been raised by the learned judicial officers as to whether a sentence of 1 month, more than 1 month, can be imposed under section 125 clause 3 CRPC in one go. In the latest case of Balraj versus Priya, criminal revision number 1218 of 2021, decided on 12th of November 2021, it has been held by our Honourable High Court, relying upon the earlier judgment of the Honourable Supreme Court in Shahada Khatun versus Amjad Ali, that no composite sentence more than 1 month can be imposed. The court held that court in exercise of power under section 125 clause 3 CRPC cannot impose composite civil imprisonment in case of default in payment of maintenance arrears allowances for a period of more than 1 month in a single stroke. If at all the default persists, even after the expiry of 1 month, the only remedy available to the aggrieved party would be to approach the magistrate concerned again after the expiry of 1 month for enforcing her maintenance by sending the delinquent husband to civil imprisonment. Thus, at one time, at one go, only a sentence of 1 month can be imposed. The relevant observations of the Honourable High Court I have already reproduced here, and I will read the important observation, which is that what flows from the Shada Khatun's case is that the defaulter can under no circumstance be ordered to undergo composite civil imprisonment for a period beyond 1 month, irrespective of the fact whether the areas claimed in a single application by the agreed party is more than 1 month or not. I will here deal with the certain queries raised by the learned judicial officers, which is on this topic only. So I will try and answer them. The first query is, in cases of civil imprisonment of husband, what is the maximum time for which he can be detained? So as I have already answered, he can be detained for only maximum period of 1 month in one go. Though subsequently, if the husband fails to pay arrears, he can again be sent to the civil imprisonment. Secondly, the merely imprisonment does not wipe out the arrears in such cases, as we will discuss a little while later. The second question is, can a husband be detained for arrears of maintenance for a period of 1 year in continuity while finally disposing of Domestic Violence Act application? The query raised is regarding Domestic Violence Act and not regarding Section 125 subclause 3 CRPC. Under Section 125 subclause 3 CRPC, we cannot impose a sentence for more than 1 month. But a magistrate under Domestic Violence Act under Section 31 is authorized to impose an imprisonment of 1 year and fine. So definitely in case of Domestic Violence Act, he can be sent to imprisonment for 1 year in a continuity. The third question raised by the learned judicial officers is, there is an execution petition under Section 125 CRPC where the judgment debtor is behind bars in some other case. The decree holder wife wants to get the property attached standing in the name of judgment debtor's father, asserting that it is an ancestral property. How to proceed? So the question raised is that whether the ancestral property of the husband can be attached in execution proceedings under Section 125 CRPC. I have searched the law on the subject and I have got a judgment of our Honourable High Court in Harjeet Singh versus Manjeet Kaur, decided in the year 2004. In the said case, which pertains to Motor Accident Claims Tribunal, though the provision is regarding Motor Accident Claim Tribunal, however, the question of law and answer would be applicable in the cases of maintenance cases also. Though our Honourable High Court in the said case has categorically held that the undivided share of a co-partner can be sold and attached in execution of a decree. Still further, after the sale being effected, it would operate as division of estate and cause variance of interest. Thus, even an undivided share of the husband in ancestral property can be attached and sold in execution of a decree of maintenance. However, in such cases, from the date the property is sold, it would be amount to division of estate and cause variance of status as held by our Honourable High Court in the judgment of Harjeet Singh versus Manjeet Kaur. The next question raised by the learned judicial officer is, if the petitioner has filed her petition seeking maintenance under Section 125 CRPC on 1st of January 2015 and the same was allowed on 1st of January 2017 for rupees 5,000 per month with effect from the date of filing. And when the maintenance amount remains unpaid, then she files the execution application only in January 2020, claiming entire amount with effect from 1st of January 2015. In such a situation, whether the conditional warrant of arrest against the respondent can be issued for the entire unpaid amount or the same should be issued only for 1 year as mentioned in proviso attached to section 125 subclause 3 CRPC. So in this case, as per section 125 subclause 3 CRPC, since the limitation is of 1 year, only conditional warrant for 1 year can be issued in such an application. However, even if the person does not pay arrears of 1 year, he cannot be sentenced for more than 1 month in one go. The only sentence which can be passed in such cases at one go is only for 1 month. Though the mere imprisonment of the husband will not wipe out the arrears and the wife can still claim the arrears and she can come again in case of a default. But at one stretch, he cannot be sent to imprisonment for more than 1 month. The judgment of the Honourable Supreme Court in Shahada Khatun versus Amjad Ali 1999 is to same effect which has been relied by our Honourable High Court in the latest case in the year 2021. Our Honourable High Court in the case of Vishal versus Bunni Devi in the year 2017 has held that court must exercise discretion while deciding maximum penalty under section 125 subclause 3 CRPC. Thus, the court has to exercise discretion whether 1 month a person has to be sent for imprisonment for 1 month or even a lesser period. The relevant observations of the Honourable High Court reads, the court has to exercise its discretion in each and every case and decide the maximum penalty which should be imposed. Whether a lesser punishment is sufficient, a month's imprisonment for every default is not the rule, and sentencing cannot be mechanical. The court has to apply its mind, consider the circumstances of each case, and decide about the quantum of punishment, having due regard to the statutory maximum limit of 1 month for each default. Thus far, in this judgment also, the Honourable High Court has held that the maximum punishment is for 1 month only for each default and cannot be more than that. To summarize all these issues, which are very important, the defaulter cannot be sent to civil imprisonment for more than 1 month at a stretch. After the expiry of imprisonment of 1 month, the defaulter has to be released from custody forthwith. However, the wife is at liberty to file fresh application alleging non-compliance of the order if the payment is not paid. The mere fact that the husband has undergone civil imprisonment does not wipe out the areas of maintenance and the wife can recover the same. Under no circumstances, a husband can be ordered to undergo composite civil imprisonment for a period beyond 1 month, irrespective of the fact that areas claimed in a single application by the aggrieved person may be more than 1 month. It has been held in the Irshad Haji Risal versus State of Uttar Pradesh that before issuing recovery warrant against the husband, the objections of the husband has to be decided. Issuance of recovery warrant against the husband without first deciding his objections under section 125 CRPC is improper. It is the duty of the court to first decide objections filed by the husband before resorting to section 125 subclause 3. The magistrate has to make sure that the person against whom it is proceeding is one who he was ordered to pay maintenance or interim maintenance and he failed to comply with the order, and that such failure is without any sufficient cause. The same applies to the case of family courts also. The imprisonment under section 125 3 CPC can only be simple imprisonment, and there cannot be a rigorous imprisonment under section 125 subclause 3 CRPC. This is very important. The imprisonment of a husband under section 125 subclause 3 CRPC does not discharge the liability. Honorable Supreme Court in Kuldeep Kaur versus Surinder Singh 1988 Supreme Court has held that where the husband has failed to pay the maintenance and is sentenced to imprisonment, it is not a mode of discharging liability. Liability arising out of the order of maintenance would not stand discharged upon an effort being made to recover the same. Order of monthly allowance can be discharged only upon monthly allowance being recovered. Liability cannot be said to have been discharged upon sending the person liable to jail. Husband is not absolved of his liability to pay maintenance allowance by reason of his undergoing sentence of jail. The amount is still recoverable notwithstanding that husband has remained in jail. So the limitation is concerned, I have already discussed, it is 1 year from the date of order under subsection 3 of section 125 CRPC for issuing warrant of imprisonment. However, if one application for recovery is pending, application for subsequent period can be filed in the same proceedings, and such an application is not barred by limitation. It so happens that wife files an application for recovery of say 6 months period, but that application remains pending for say 2 years. Then in such a case, she can file a subsequent application in the same proceedings, and the husband cannot take a plea that since the period of 1 year has already elapsed before filing the application, it is barred by limitation. Our Honourable Supreme Court in Shanta versus BG Shivanagappa in the year 2005 has held so. It has been held that liability to pay maintenance under section 125 CRPC is in the nature of continuing liability. If one application for recovery is pending, the application for subsequent period can be filed in the same proceedings and is not barred by limitation. Second exception is that the period during which order remained stayed is to be excluded while continuing period of 1 year under section 125(3) CRPC. Thus, the maintenance is decided by the court, but the husband goes in appeal in a higher court, and in such case, the order of maintenance remains stayed, then such period has to be excluded as held by the Honourable Supreme Court in Amrendra Kumar Paul versus Maya Paul. The third manner of recovery of maintenance is under section 128 CRPC. In this regard, it is very important to note that the limitation of 1 year under section 125(3) CRPC is not applicable in case of section 128 CRPC. It has been held by the Honourable Allahabad High Court in the latest case of Muhammad Usman versus State of UP, which has been decided on 31st of August 2021, that section 125(3) of the code would have to be applied and confined to section which it precedes. Hence, the limitation of 1 year provided in terms thereof would have to be read in relation to issuance of a warrant for recovery of an amount due in terms of order of maintenance passed under subsection 1 of section 125. The aforesaid limitation of 1 year under the proviso to section 125 subclause 3 CRPC cannot be held to travel beyond and stretch to extent so as to bring within its ambit the power relating to enforcement of an order of maintenance under section 128 of the code. To same effect is the earlier judgment of the Honourable Madras High Court. The third manner of recovery of the maintenance is by attachment of the salary of the respondent for payment of areas of maintenance. This is one of the easiest method. If the husband is working somewhere, the warrant for attachment of the salary can be issued and the employer deducts the amount and deposits in the court, which can be released to the wife. And this is one of the easiest method I've seen regarding recovery. And first method, if he is an employee, I adopt in my code. As per section 60 clause IA of CPC, only 1/3 of the salary in execution of any decree for maintenance is not liable for attachment, meaning thereby 2/3 of the salary can be attached in execution of a decree for maintenance. Thus, 2/3 of the salary of the husband can be attached in an execution for decree of maintenance, whereas in other cases it is 1/3. 1/3 of the salary. So a wider amplitude has been provided for maintenance cases by the legislature under clause I and clause IA. Still further, other conditions like exemption of first 1,000 rupees and exemption from attachment after 24 months and other such conditions in clause I are not applicable in case of maintenance. It has been held by our Honourable High Court in Madhav Kumar Anand versus Sudesh Kumar in the year 1984, way back in 1984, that attachment of salary even outside the jurisdiction of the court can also be made. We have discussed the judgment of the Delhi High Court in the year 2021. Our Honourable High Court in case of salary has held so in the year 1984 itself that a magistrate at Amritsar can issue warrant for attaching pay of husband at Jammu in case of default in payment of maintenance. However, so far as General Provident Fund of the husband is concerned, the same cannot be attached for non-payment of maintenance as held by our Honourable High Court in Sarvan Kumar versus Premlata in view of Section 3 of Provident Fund Act 1925. So in view of the said statutory protection, the General Provident Fund of the husband cannot be attached for recovery of maintenance amount. Now, so far as the recovery of areas of maintenance under Hindu Marriage Act and Special Marriage Act is concerned, the orders and decrees of maintenance can be enforced like a decree of civil code through the provisions which are available for enforcing a money decree, including civil detention, attachment of property as provided under various provisions of the CPC, more particularly Section 51, 55, 58, 60 and Order 21. The Section 28 of the Hindu Marriage Act and Section 39A of the Special Marriage Act, which are paramateria, provide for this. Under the Code of Civil Procedure, the order of maintenance can be executed by attachment and sale or by sale without attachment of any property subject to the conditions under Section 55 and 58 of CPC. Secondly, the order can be executed by attachment of salary, which we have already discussed, subject to Section 60 Clause IA CPC, that 1/3 of the salary cannot be attached. And thirdly, by arrest and detention in prison, subject to conditions under Section 55 and 58 CPC. Here it is pertinent to mention that CPC provides certain restrictions and conditions under which a person can be sent to civil imprisonment. However, insofar as Section 125 Clause 3 CRPC is concerned, no such restrictions have been provided. So the scope of Section 125 Subclause 3 CRPC is much wider than provision under the Code of Civil Procedure. The next method of recovery and is by striking of the defense of the respondent. So far as civil cases are concerned, there is no dispute that the defense of the respondent can be struck off in case of non-payment of maintenance, as has been held by Honourable Supreme Court in the latest case of Rajneesh versus Neha, and our Honourable High Court to quote a few in Rani versus Prakash Singh. While considering a case where the husband failed to comply with maintenance order despite several notices for a period of over 2 years, has held that the court can strike off the defense of the respondent. The Honourable High Court held that law is not that powerless as not to bring the husband to book if the husband has failed to make payment of maintenance and expenses to wife, his defense be struck out. However, so far as Section 125 CRPC is concerned, there is some conflicting judgments regarding striking of the defense. Our Honourable High Court in Gurvinder Singh versus Murthy, while considering a case where trial court struck off the defense of the husband for non-payment of ad interim maintenance, has set aside the order of the trial court and held that instead of following the correct procedure for recovery of interim maintenance, as provided under Section 125 subclause 3 or Section 421 of CRPC, the trial court erred in striking off the defense of the husband. The error of the court did not assist in recovery of interim maintenance, but rather prolonged the litigation between the parties. This judgment of our Honourable High Court has been cited in Rajneesh versus Neha also by the Honourable Supreme Court. Similarly, the Honourable Madhya Pradesh High Court in Venkateshwara Dwivedi versus Ruchi Dwivedi has held that neither Section 125 Clause 3 CRPC nor Section 10 of the Family Courts Act either expressly or by necessary implication empower the magistrate or family courts to strike off the defense. A statutory remedy for recovery of maintenance was available, and power to strike off defense does not exist in proceedings under Section 125 CRPC. Such power cannot be presumed to exist as an inherent or implied power. To same effect is the judgment of Honourable Kerala High Court also in Davis versus Thompson and Karnataka High Court in Ravindra Kumar versus Renikul. It is pertinent to mention that these judgments have been noticed by the Honourable Supreme Court in the latest case of Rajneesh versus Neha in the year 2021. Honourable Supreme Court in Rajneesh versus Neha has held that striking out the defense of the respondent is an order which ought to be passed as a last resort if the courts find default to be willful and contemptuous, particularly to dependent, unemployed wife and minor children. Thus, the defense has to be struck off only as a last resort. It is not to be struck off that say for 1 or 2 hearings the husband fails to pay the maintenance and we strike off the defense and proceed against the husband. So as per the judgment of the Honourable Supreme Court, that course of action has not to be resorted to because the law, the rules of procedure are handmaid of justice and every effort must be made by the court to hear the parties on merits of the case and decide the case on merits. Insofar other methods of recovery is concerned, as held by Honourable Supreme Court in Rajneesh versus Neha, contempt proceedings can also be initiated for willful disobedience regarding the maintenance orders. However, a writ petition is not maintainable for recovery of areas of maintenance as held by Honourable Calcutta High Court in Archana Pradhan versus State of West Bengal. So a writ petition cannot be filed in before the Honourable High Court for recovery of areas of maintenance. Next is issue regarding defaulter residing abroad. It is very difficult to execute an order in ordinary civil case. Then it is more difficult if it is a maintenance case, and it is utmost difficult if the defaulter is residing abroad in normal day-to-day functioning we have seen. However, in the latest case of Asha Devi versus Munishwar Singh, it has been observed by the Honourable Delhi High Court that maintenance order can be enforced against a person even when he is abroad. Though these findings are only a passing reference and it was not a matter and issue and only obiter dicta by the Honourable Delhi High Court. The issues of recovery of maintenance from defaulters residing abroad is specifically dealt by Maintenance Orders Enforcement Act 1921, read with Maintenance Orders Enforcement Rules 1955. The Maintenance Orders Enforcement Act 1921, which was originally enacted to facilitate the enforcement in India of maintenance orders made in the colonies of Britain, was amended in the year 1952 and now provides for establishment of arrangement for enforcement of maintenance orders on reciprocal basis between India and other reciprocating territories outside India. Section 5 of the said Act provides for transmission of maintenance orders made in India to the reciprocating territories for enforcement. Then there are maintenance order enforcement rules of 1955, which have been framed under the Act of 1921, which defines reciprocating territory to mean any country or territory outside India in respect of which Act for the time being applies by virtue of a declaration under Section 3 of that Act. The Section 3 provides that if central government is satisfied that legal provision exists in any country or territory outside India for enforcement within that country or territory, then central government may by notification in official gazette declare the act to be applicable to such country or territory. The Punjab and Haryana High Court Rules and Orders, Volume 3, Chapter 7, Part B, deals with the aforesaid provision and provides for the list of countries mentioned in the aforesaid chapter. So we can refer to the provisions of the our High Court Rules and Orders, Volume 3, Chapter 7, Part B. So far as execution of conditional warrants is concerned, Ministry of Home Affairs is the nodal agency.
Excuse me, Mr. Mittal, could you kindly now conclude the session, please?
Please, I will. Ministry of Home Affairs is the nodal agency for seeking execution of conditional warrants, and there are mutual legal assistance treaty countries and non-mutual legal assistance treaty countries, in which summons and warrants can be enforced, and the procedure is prescribed on the site of the Ministry of Home Affairs, which I will be supplying a write-up which contains all the details. I am very thankful to all of you for giving me a patient hearing, and I am very thankful to Honourable Mr. Justice Vivek Puri, Judge, Punjab and Haryana High Court, Chandigarh, for his valuable guidance and for guiding us on this topic of maintenance. Thank you very much, sir.
Thank you, Mr. Mittal, so much. You have dealt with the entire subject in such depth, in detail, and cataloguing the different cases which have come up. Honourable Mr. Justice Puri has been waiting for a long time, and we are looking forward to hear him now. May I request Justice Puri to kindly enlighten us with your concluding remarks.
Thank you, sir. First of all, I was not waiting since long. I was also a participant in this workshop, and in the bargain, I am also gainer in my knowledge. Thank you very much, Mr. Mittal. He has given a very exhaustive and elaborate presentation, so nothing much is left for me to say on the subject, but just to supplement and what he has said, and to begin with, I will say these workshops, they provide us an opportunity for introspection. All the judicial officers who are party to this event have a very, very long experience in this field, but it is an occasion to introspect as to whether what we are doing is correct. The law which we are applying is the prevalent law. Is there any scope for improvement or correction? Well, the history of family law can be traced from the codification of Hindu laws from 95, 55, 56 onwards. The law is not static. Change is the law of nature. New legislations, judicial pronouncements are introduced to meet with the changing requirements and the need of the society. The litigation is said to be an index of prosperity. If the people are aware of their right, they approach the courts of law for redressal of their grievances. Matrimonial and family disputes have multiplied many folds, and for that reason, even exclusive courts have been set up. The new legislations like Family Court Act, Protection of Women from Domestic Violence Act, even the amendments in Section 125 CRPC has to cater the need of the litigants. The courts which are seized of such matters, an onerous duty is cast upon them. The law of maintenance is a measure of social justice, and the courts are not to be a silent spectator as it has already been shared by Mr. Mittal. The courts have to play a very, very effective role. And my humble request to all of you is that there should be all-out efforts for an amicable settlement of a matrimonial dispute. I will say that no effort should be taken as a last effort to settle the matrimonial dispute in an amicable manner. The dictionary meaning of maintenance, it can be to provide some support or some sustenance. So you have to be very, very careful with regard to the quantum of compensation. It is not to be too meager, it is not to be too excessive. It should not work as an engine of operation to the husband who has to pay the amount. At the same time, it has to be commensurate with the status and the standards. Another thing which I would like to share with you people is that these proceedings under section 125 CRPC are summary in nature, and we should not let them to become a long and protracted trial. So now it is just going to be 2:45. You have to join the next session after a tea break. So my concluding remarks are hard work and on this was displayed in this presentation by sincere to Dr. Gupta, Chandigarh Judicial Academy. Thank you very much.
Thank you so much, Justice Puri. We have taken a lot of your time, but as you put it, you were a participant also. So humble on your part as such. Thank you so much. I also thank Mr. Hemraj Mittal, who had worked hard and made this presentation. Thank you so much, Mr. Mittal. We look forward to meet again. Thank you.